Tonight, former Finance Minister Ken Ofori-Atta and 7 others slapped with 78 counts, including causing financial loss and conspiracy to commit the criminal offense of influencing procurement process to secure unfair advantage in the SML scandal. We'll bring you details of this story here on Top Story, always brought to you by Telecel Connecting Energies, Holy Insecticide Spray and Coil, Enjoy Holy Sleep, and also by Shield Pension Trust, into the future with you. Now, tonight, Ghana's most wanted, former Finance Minister Ken Ofori-Atta and 7 others have finally been dragged before court, charged with 78 counts, including causing financial loss and conspiracy to commit the criminal offense of influencing procurement process to secure unfair advantage in the SML scandal. The case stems from the SML revenue assurance contract, which had cost the state over $141 million by 2023. Mr. Ofori-Atta later extended the agreement in October 2023, an expansion expected, which would have expected them to commit the state to more than $100 million annually for 5 years, which with the possibility of a further 5-year renewal. Joining me in studio is my colleague here, Caleb, who is with the research team with more from this particular chat sheet. Caleb, I mean, let's start with who exactly has been charged here.
8 persons have been accused, and they include the former Finance Minister Ken Ofori-Atta. Then we have Ernest Darko Akori. He's the chef de cabinet to former Finance Minister Ofori-Atta, or his chief of staff. Then we have Emmanuel Kofi-Nti. He's the former GRA commissioner. And we have another former GRA commissioner. This is Amishadai Owusu Amwa. Then we have Isaac Crensil, former commissioner of the GRA's Customs Division. Then we have Colonel Kojo Damwa. He's also another former commissioner of the GRA's Customs Division. And finally, we have Evans Eduse, the CEO of SML. And we also have SML itself as an accused. So we have 8 of them from Ofori-Atta, and we have his chief of staff, and then we have 2 former GRA commissioners, 2 former GRA commissioners of the Customs Division, and then the CEO of SML, Evans Eduse, and then SML itself.
Let's now look at the particulars of the case that has been filed.
Yeah, so the case was filed today, 18th of November 2025, and the 8 persons have been charged with a total of 78 counts. And some of the key charges are directly or indirectly influencing the procurement process to obtain an unfair advantage in the award of a contract, also causing financial loss to the Republic, and then using public office for profit. Now, there are 78 of them, but these are the main ones. So some procurement breaches, causing financial loss to the states, and then using public office for profit. So these are the main charges that have been filed against the accused. But again, we have 78 of them. And the OSP says that the accused persons conspired or took steps to run what they describe as a criminal enterprise. And then the accused persons directly and indirectly influenced the procurement process to secure unfair advantage for SML in the award of several contracts which spanned from 2017 to 2024. And also mandatory approvals from Parliament and from the Board of PPA were ignored. So these are the main facts of the case, that mandatory approval from the PPA and Parliament for most of the contracts were not sought. Also, there was what the OSP terms as a criminal enterprise, where people from the Finance Ministry, GRA, and SML worked together to secure some contracts in favor of SML. And this started from 2017 to 2024.
Now, how much are we told we've lost in this particular matter?
Yeah, so according to the charge sheet, the total financial loss to the state is 1.4 billion Ghana cedis. That's 1.4 billion Ghana cedis. And the charge sheet broke it down a bit for us. So between June and December 2018, 18.5 million cedis was paid for what was described as transaction audit services. And according to the OSP, there was no validation, there was no evidence of performance, and there was no actual delivery of the service under the contract that was unlawfully, according to the OSP, unlawfully secured through single source procurements without the approval of the PPA board. Also, between April 2018 and May 2019, 15.9 million cedis was paid by GRA for some external verification services. Again, between October 2019 and February 2024, a further 900 million cedis was paid for the measurements of audits of downstream petroleum products. Now, the OSP says that these payments were based on false claims by SML that they had the experience to validate some of the petroleum delivery in the country. And also, again, the contract was awarded through single source without the required approvals from Parliament and the PPA board. Now, according to the OSP again, those involved, as those are the Finance Ministry and those are GRA, ought to have known or knew that the payments were based on false claims of technical experience. So the OSP says SML did not have the technical experience for the service that they said they were providing for the states. So according to the OSP, those involved, as at the Finance Ministry and GRA, knew or they ought to have known that SML did not have this capacity to perform the audit delivery service, and this contract should
that
not
it
have been
didn't
awarded.
do the job at all.
Yes, so in some instances, the job was not done, and there was no verification by GRA and the Finance Ministry to ensure that the job was done. And also, SML itself did not have the capacity or the capability to do some of the revenue assurances that it said it can do for the state.
All right. Thank you very much, my colleague Caleb, with that, the details of this particular case or the suit that has been filed against Ken Ofori-Atta and the other people listed in this particular story. This is the story brought to you always by Telecel, Holy Intercessor Spray, and also by Shield Pension Trust. Let's bring in more people into this particular discussion. Adam Senano is an anti-corruption campaigner. He joins us via Zoom. I'm grateful to you, sir, for joining. Now, many people have reacted to this particular matter since it broke. What's your reaction? I haven't heard that Ken Ofori-Atta and the other people have been slapped with 78 counts.
Well, it's a challenging, difficult example of what happens when processes and systems seem to fail. The persons being mentioned are persons who've served this country, some of them at certain points in trying to promote different things. We've engaged them. And so, on one hand, as an anti-corruption activist, it is always important that the standards that allow us to preserve and protect the public purse are maintained is important. On the other hand, it is sad to see some of these persons who we thought were fine gentlemen seemingly embroiled in this, and one cannot tell where it will end. So it's a mix of emotions, but I think it's good for Ghana that these things come up. I think that everybody should be provided a fair opportunity to defend themselves when necessary, and if the charges don't stick, that would be good. But where persons have failed, where they were provided with entrusted responsibility to do what is right, and are found culpable, the law should also take its course.
But when you hear the OSP says, quote, the actions of the first, third, fourth, fifth, and sixth accused persons created the opportunity for the eighth accused company to largely pretend to perform the services under the various contracts, leading to immense financial loss to the Republic of about 1,436,249,828 cedis, 53 pesos. I mean, do you ask yourself, was nobody watching?
I do. I mean, those are shocking details. because you see, when it says that the company pretended to have the capacity, including technology that only they had that would be deployed, etc., etc. The question in my mind is, what kind of due diligence did we do to make sure that this was actually the case? Again, when they talk about the lack of both PPA and parliamentary approval, why would the Ministry of Finance proceed on a single source procurement track, knowing full well that the approval systems that were needed to ensure that this was, legit had not been followed? I mean, the question of who was watching is really cardinal, because one expected that between the chief director of the ministry, between the legal office, between the procurement office, there are too many levels at which somebody should have asked this question. Is it possible that all these aspects of the value chain did not notice that the necessary approvals had not been received, that the due diligence, because usually we say, where is the historical track record that this company has performed this function and provided this service to other entities? And that historical record shows that they are above board, they have provided distinctive service, and therefore we should go for a single source. It's just mind-boggling. So your question is on point, and it's still, even with the names mentioned there, in my mind, this could not have happened without that levels of operational, officers having been involved and not having done their responsibility. And so I don't know whether this is the full scope of who should be answering questions.
Mm. But I mean, the case is in court, right? But if SML is able to produce evidence that there was some work done, what happens to this particular charge? But I mean, they were paid for no work done.
The charges assume that the investigations, or they indicate that the investigation of the Office of the Special Prosecutor could not find evidence of targets plus verification sufficient or adequate to say we are able to say this was scientifically done. The payments were triggered by indicators of targets having been met, or of clear evidence that these certain monies were, as were secured for the state by the activities they engaged in. So I guess that it is a matter of what will be shown in court. And in my mind, really, this is more likely that the special prosecutor will have good records, because typically the Ministry of Finance, in its records, should have the documentation that show the processes, who signed off, the paper trail, plus receipts, etc., etc. It is unlikely that the special prosecutor will arrive at these conclusions if that documentation was available and easily accessible in the Ministry of Finance. So there is some gap. And I think it's going to, in my mind, it's going to be a very interesting case, because I want to assume that there is no documentation that shows how these payments were made legitimately, and that is why the special prosecutor has drawn these conclusions.
I've seen some people react to this particular matter and conclude that, I mean, it's a clandestine move to get the accused to be freed. I mean, what's your level of believability in this case from all that you've read, 78 count, and the details that are being spelled out there?
I didn't get that question. It's a subtle attempt to get the accused freed.
I mean, those reactions are going to the extent that some people have even started a campaign to get the OSP out. And I'm asking you, from where you stand, an anti-corruption campaigner, you have a lot of leads. What's your level of believability in this case that it could, if there's anyone at fault, the law can get him to face the consequences?
I I can't see how that interpretation is is connected with the charges. 78 charges that outline the failure to get the necessary legal approvals which are in our laws, which are known to all of us in the anti-corruption space. Charges that indicate the quantum of loss to the state that has arisen because we didn't do the due diligence. Charges that indicate that clearly not only was it a case of due diligence not being followed, but the company that said it had a certain capacity did not have that capacity. How could these be a subtle attempt to get the OSP off? There's something quite upside down about that kind of logic. I can't follow it.
So you have trust in what's happening?
It's not about trust.
Okay.
It's about the facts. I mean, for all of us, we deal with the facts. The evidence suggests that, and it's clear. We know what the parliamentary approval process for this required. We know what the PPA approval process requires. We know what it needs for you to get single source approval. Mind you, if I remember right, part of the reason why they didn't get the approval was the PPA had earlier refused to give them approval. If I remember my facts from the last 2 years, it wasn't that they didn't go through the process. The fact that the SML did not have the proprietary rights to whatever software they are talking about or system, and therefore did not have the capacity. This can only be tested as facts in court that there was no legal document show that they have the capacity or not. I don't see how. I mean, it's not a matter of trust. It's a matter of the facts going to court, and it's up to the judicial system to adjudicate and say that, yes, for a fact, we find this person culpable for reaching the laws of the land.
Okay. I'm grateful to you. Let me bring in now Frank Davis. Do stay with me, Adam Senano. Let me bring in Frank Davis, who is counsel for Ken Ofori-Atta. I'm grateful to you, sir, for joining us here. I mean, when you heard the matter or the charges preferred against your client and other people, what was your reaction?
Good evening to your esteemed listeners and cherished viewers. I am lawyer for Kenneth Nanaya Okuntukunuku Ofori-Atta.
Okay.
What do I make of the charges?
When you had those charges preferred against your client?
Oh, I long expected it, so it doesn't come as any huge surprise to me. But when I did the tabulation, it was about 78 counts.
Yes, 70.
And I said, wow. The OSP has a long-headed climb. 78 pounds. We'll wait. So I've seen it on social media, as you have also seen on social media.
I mean, if you say he has a long head to climb, you are a lawyer. Help us understand. What do you actually mean?
Oh, but you have to prove every single count beyond all reasonable doubt. You can't lump them together. So what I'm saying, you will have to prove 78 counts. And it is a hurdle, or it's not a hurdle to you. 78. So,
I mean, he says the actions of your client and the others accused created an opportunity for the 8 accused company to largely pretend to perform functions or services under the contract, leading to the immense financial loss to the Republic, meaning that your client knew the company was doing nothing, but they were being paid.
I don't speak for SML. So don't throw me into their route. I don't speak for SML. Maybe when you engage the SML lawyers, they can explain the question you're asking. I speak for Nana Yao, Kenneth Kuntunkunuku Ofori-Atta. So I'll answer questions relating to him, not to SML.
It is his question.
I don't know what I'm going to say about SML. I can only speak for what my client stands charged with. So if we can go on.
So, I mean, he says that your client, who is the first accused here, created an avenue for SML to pretend as though it is working what it is not, and was being paid for no work done. And I'm asking, this is the claim that your client sat there, paid people for no work done. When
I am not a lawyer who discusses his case on radio. I don't do that. I can only speak on the threshold as to facts and certain dangling legal questions. But as to whether my client is liable or not, it's not for me to say on radio. Indeed, the duty of the prosecution is to prove the guilt of the accused person. It does not end with just scribbling or scripting long English and grammar. He will have to go to court and prove it. So whatever he's saying, if he says so, the real McCall is going to court. That is what I've always been saying. That a lawyer's day is in court, not on radio, in front of microphones, and in front of cameras. I do my legal work in the courtroom. At least that was how I was taught to train. So I will not answer questions pertaining to the charge on radio.
Okay.
Indeed, it will be an affront to the ethics and of the profession.
Okay.
I can't do that.
But I mean, if you hear this count or these charges against your client, doesn't it scare you and your client? 78.
Oh, scare! Oh, wow! I think you should be more charitable to him. You should be more charitable to him.
Okay.
I have said, and I repeat ad nauseum, that Kenneth Nanaya Kuntun Kunuku Ofori-Atta is not scared of prosecution. Never. And I am not scared of the courtroom. So you have two persons who are not scared. So we are there. When the day comes, we will have our time in court.
Are we going to see him avail himself in court?
Why? What is your problem? That you think he won't come?
No, I only want to know.
Oh, when he is formally notified of the charges, of course, he knows what to do. But don't forget that the special prosecutor has told the whole country that he's going to force his entry into the country. So that is another option. Or
But he has not been served officially.
I don't know about that. At least he has not spoken to me that he's been notified of the charges. I believe we have all seen it on social media as you have. And I believe that Ken, being the Ken I know, maybe will have chance on it on social media. But I don't know of a personal notification to him.
How is he though? All of us are concerned.
How is he?
How is he doing?
Oh, the good Lord God is keeping him every day, as he keeps all of us. You are well, aren't you? He's also well. He is recuperating from his surgery, but he's fine, I can confirm.
Okay. We'll see when the matter is called in court.
Thank you very much.
Wish you all the best. Frank Davis is counsel for Ken Ofori-Atta. The Adam Sedano is... So, Mr. Sedano, I mean, as we leave this whole thing and then look at what will happen in future, what's your expectation of how this case will travel?
Well, honestly, I don't have a personal expectation beyond that the good people of this Ghana, of the good people of this country, will not suffer any more losses. I'm thinking through how we identify what were the gaps. Because if truly we lost 1.4 billion through this, we need to understand what exactly went wrong and how do we prevent a recurrence of these things. And we shouldn't have to take that many years to get to the point of realizing that we have gaps like this. I certainly don't find any excitement with people having to be incarcerated or jailed. But if it will serve as a deterrent, because at the end of the day, the evidence is clear and incontestable, uncontestable, that this is truly what transpired, then let the law take its course.
Okay.
And let persons who have to be sanctioned to serve as a deterrent and to set a right precedent for other public officers. And those are signed and appointed by government to make sure that they do better when they are appointed.
I'm grateful to you. Adam Senano is an anti-corruption campaigner. This has been Top Story, brought to you always by Telecel Connecting Energies, Holy Insecticide Spray and Coil Enjoy Holy Sleep, and also by Shield Pension Trust. Into the future with you. My name is Samuel Kojo Brace. Up next is Newsnight after these.
Auntie T, abeg, fix me gobetete Ghana. No gari, no oil, no plantain, just beans then eggs.
Hey,